Hi students, welcome to lesson number 21 on National Policy for Backward Classes and Minorities. The introduction. It would be nearly impossible to imagine Indian society and polity without the identities of backward classes and the minorities. The backward classes constitute an important segment of Indian society and they account for more than 30% of the total population. Their condition is intimately connected with many of the basic features of Indian social structure, and the minorities constitute 20% of the total population of the country. It is therefore necessary to understand that each of these categories not only influences economic, social and political life in India, they also belong to the marginalized sections of society. In the past some years, there have been a growth in the level of their political consciousness and political mobilization. In response to their political mobilization, the state has responded with some policy formulations. This has led to their empowerment to a considerable extent. However, despite the relative improvement in their condition in the post-independence period, the OBCs and the minorities still remain marginalized groups in India. So, it is necessary to come out with concrete policies and measures to safeguard their position in the society. This lesson will help the students to understand who are backward classes and minorities, and they can also understand the various policies meant for their development. Now, who are backward classes? Backward classes are also known as backward classes or other backward classes. Our constitution identifies those social groups as OBCs which are educationally and socially backward. This categorization includes those groups among the OBCs which are not necessarily backward politically or economically. That is, why a large number of the castes identified as OBCs are quite influential in politics and economy, especially agriculture in different states of India. Unlike Dalits, OBCs is a more differentiated category. It includes the intermediary land owning caste as well as a landless service caste. The land owning middle or intermediate castes are mainly Jats, Yadavs, Gujars, Loths, Kurmis in the North India, Marathas and Patels in Maharashtra, and Gujarat and Reddis, Khammas, Vokaligas and Lingayats in South India. It is these castes which are more assertive among the OBCs. Socially belonging to the middle or intermediate caste, they have benefited from the land reforms and green revolution. They also own the maximum resources and land in rural society. Some of them have been diversified into non-agricultural economy. Thus, the sphere of influence cut across the towns. Now, we will understand the organizations of backward caste. A large number of backward class associations appeared in the post-independence period. Mark Galanter observed that by 1954, there were 88 organizations in India which articulated the interest of the backward classes. The most important of these existed in North India. These were UP Backward Classes Federation and Bihar State Backward Classes Federation. These two organizations merged on 26 January 1950 to form All India Backward Classes Federation, that is AIBCF, by the efforts of 𝗪𝗪𝗺 𝗪𝗏. The AIBCF had split into two groups, one adhering to the Congress ideology and another loyalty to socialism. The former was represented by 𝗪𝗪𝗺 𝗪𝗏 and the latter by R.L. Chandrapuri. R.L. Chandrapuri formed Indian National Backward Classes Federation on 10th November 1957. And these organizations sought to get the reservation for the OBCs and empower them in order to overthrow the Brahmin Baniya Raj. The organizations contributed to the rise of consciousness of the other backward classes, and these consciousness coupled with the result of land reforms and adequate numerical strength led to the assertion of the OBCs or the other backward classes. However, 𝗖𝗵𝗍 had become defunct by the 1970s, but a generation of the backward classes has already emerged on the political scene, which became more effective during the Janata Party regime. It was due to efforts of this section of the OBCs leadership that the Janata Party government had appointed the second backward class commission known as Mandal Commission, named after its chairman B.P. Mandal. The implementation of Mandal Commission report in 1989 in seeking to introduce 27% reservation for the OBCs in the government jobs changed the contours of Indian politics. The present phase of backward classes assertion is a sequel to their assertion in the years surrounding the achievement of independence of the country from colonial rule. And this had led to the appointment on January 29, 1935 of the first backward classes commission known as the 𝗂𝗽𝗪𝗪 Commission, which was headed by Kaka 𝗂𝗪𝗪. Purpose of 𝗂𝗪𝗪 Commission was to determine the criteria to identify socially and educationally backward classes in India in order to enable the government to introduce policies for their betterment. But there were differences among the commission members on the criteria which was to be followed to determine the backward class status of a community. One section supported the caste as a criterion and another class. The 𝗂𝗪𝗪 report was presented to the central government, but the government decided against introduction of reservation to the backward classes. 𝗂𝗪𝗪 report, however, occupied a prime place in the agenda of the backward classes organization. They demanded appointment of another backward class commission, and the appointment of the second backward class commission, that is Mandal Commission, was a result of it. Now, we will talk about the National Commission for Backward Classes Act 1993. This commission was established upon the implementation of the Mandal Commission recommendations reserving 27% reservation of jobs in central services to the persons belonging to other backward classes. According to the 1993 Act, backward classes means such backward classes of citizens other than the SCs and the STs as may be specified by the central government in the list drawn from time to time. The NCBC consists of a chairperson, a sitting or a former judge of Supreme Court or of High Court, a social scientist, and 2 persons having special knowledge in matters relating to BCs, and a member secretary who is or has been a secretary level civil servant with the union government. These members hold office by a term of 3 years. The Commission's main function includes the examination of requests for inclusion of any class of citizen as a backward class in the list and hear complaint of over inclusions or under inclusions of any backward class in such list prepared by the central government and tender advice on the matter. And such advice of the Commission is ordinarily binding upon the government. The central government is mandated to revise this list at the interval of every 10 years with a view to excluding or including new backward classes. While undertaking such revisions, the government shall consult the Commission. Now, we will understand who are the minorities. Minority is referred to as a community notified as such by the central government. Government of India has declared 6 religions, namely Muslims, Christians, Sikhs, Buddhists, Parsis and Jain, including 2014 as religious minorities in India. Now, we will understand the constitutional provision for minorities. Constitutional provisions related to minorities can be seen in the fundamental rights, directive principles of state policy and constitutional rights. Now, what are the fundamental rights meant for minorities? Under Article 14, it talks about people's right to equality before the law and equal protection of the laws. Under Article 15, it says that prohibition of any discrimination against any citizen on grounds of religion, race, caste, sex or place of birth. Article 16 of the Constitution states citizen rights to equality of opportunity in matters relating to employment or appointment to any office under the state and prohibition in the regard of discrimination on grounds of religion, race, caste, sex or place of birth. Under Article 25, it states people's freedom of conscience and right to freely profess, practice and propagate religion subject to public order, morality and other fundamental rights. Article 26 cites the rights of every religious denomination or any other section thereof subject to public order, morality and health to establish and maintain institutions for religious and charitable purposes and manage its own affairs in matters of religion, own and acquire movable and immovable property and administer it in accordance with law. Article 27 cites the prohibition against compelling any person to pay taxes for promotion of any particular religion. Article 28 cites people's freedom as to attendance at religious instruction or religious worship in education institutions wholly maintained, recognized or aided by the state. The directive principles of state policy includes the various provisions and they have significant implications for the minorities, and it includes the first one, the obligation of the state to endeavor to eliminate inequalities in status, facilities and opportunities amongst individuals and groups of people residing in different areas or engaged in different vocations. Article 38(2). Second, the obligation of state to promote with special care the educational and economic interests of the weaker sections of the people under Article 46. Now, the constitutional rights. The Constitution refers to two types of minorities, namely religious minorities and linguistic minorities. However, the term minority has not been defined anywhere in the Constitution. In 1993, the central government notified 5 communities, namely Muslims, Christians, Sikhs, Buddhists and Zoroastrians, that is Parsis, as religious minorities at the national level. In January 2014, the Jain community was added to this list. A linguistic minority is a group of people whose mother tongue is different from that of the majority in the state or part of a state. This means that linguistic minorities are determined on a state-wise basis. The Constitution contains special provision to safeguard the social, educational and economic interests of the minorities. Some of these are common to both religious minorities and linguistic minorities, while some others are meant exclusively for linguistic minorities. Hence, these provisions are mentioned under 2 headings. The first one, religious and linguistic minorities. Any section of citizens having a distinct language, script or culture of its own has the right to conserve the same under Article 29(1). No citizen is to be denied admission into any education institution maintained by the state or rated by the state on grounds of religion, race, caste or language under Article 29(2). All minorities, whether based on religion or language, have the right to establish and administer education institution of their choice under Article 31. A minority educational institution should not restrict or abrogate the right guaranteed by the minorities, whether based on religion or language, that is under Article 31A. So, in granting aid to education institution, the state should not discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language under Article 32. The wearing and carrying of kirpans shall be deemed to be included in the profession of the Sikh religion. In other words, Sikhs have the right to wear and carry kirpan under Article 25(2). Linguistic minorities, when the President on a demand being made is satisfied that a substantial proportion of the population of a state desire the use of any language spoken by them to be recognized by that state, then he may direct that such language should also be officially recognized in that state under Article 347. So, every aggrieved person has a right to submit a representation for the redress of any grievance to any office or authority of the union or a state in any of the languages used in the union or in the state, as the case may be. This means that a representation cannot be rejected on the ground that it is not in the official language under Article 350. Every state and a local authority in the state should provide adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups. The President can issue necessary directions for this purpose under Article 350A. The President should appoint a special officer for linguistic minorities to investigate all matters relating to the constitutional safeguards for linguistic minorities and to report to him. The President should place all such reports before the Parliament and send to the state governments concerned. Article 350B. Now, we will talk about National Commission for Minority Educational Institutions Act 2004. It provides additional safeguards to the minority educational institutions, and it contains provisions for the establishment of a National Commission for Minority Educational Institutions right to establish a minority education institution, right of a minority education institution to seek affiliation to any university of its choice. WAFC Act 1995 was enacted to safeguard the existence of a large number of WAFC properties in the country. The Act provided for the establishment of a Central WAFC Council for the purpose of advising the Government of India on matters pertaining to working of the state WAFC boards and proper administration of the WAFCs in the country. A WAFC is a permanent dedication of movable or immovable properties for purposes recognized by the Muslim law as religious, pious or charitable. Apart from this religious aspect, the WAFC are also instruments of social and economic upliftment. Now, we talk about the National Commission for Minorities, that is NCM. With a view to ensuring effective enforcement of the implementation of constitutional provisions relating to minorities, a National Commission for Minorities was created in 1978, which was given statutory status in 1992. According to the government notification, these minorities include the Muslims, Christians, Sikhs, Buddhists and Zoroastrians. NCM consists of a chairperson, a vice chairperson and 5 members belonging mostly to the minority communities. The chairperson and member hold office for 3 years. The commission performs among others the following various functions which evaluate the progress of the development of minorities under the union and states, monitor the working of safeguards provided in the constitution and in laws enacted by the parliament and the state legislatures, which make recommendations for the effective implementation of safeguards for the protection of the interest of minorities by the central government or the state governments. And they also look into various aspects such as, first one, they look into specific complaints regarding deprivation of rights and safeguards of the minorities and take up such matters with the appropriate authorities. Studies to be undertaken into problems arising out of any discrimination against minorities and recommended measures for their removal. Conduct studies, research and analysis on the issues relating to socio-economic and educational development of minorities. Second, suggest appropriate measures in respect of any minority to be undertaken by the central government or the state government, and make periodical or special reports to the central government on any matter pertaining to minorities and in particular difficulties confronted by them. The Commission monitors the working of the safeguards provided to the minorities in the Constitution and laws. It also looks into specific complaints regarding deprivation of rights and safeguards of the minorities. Consensual safeguards, in addition to the above constituted safeguards, the linguistic minorities are also provided with some consensual safeguards. These have been arrived by consensus by the central and the state government through the series of meeting, and they have to follow certain instruction through minority languages as a secondary stage of education, translation and publication of important rules, regulation, notices into all languages which are spoken by at least 15% of the total population at district or sub-district level. No insistence upon knowledge of state's official language at the time of recruitment. Test of proficiency in the state's official language to be held before completion of probation. The constitutional and the consensual safeguards, together with practical ways to implement them, has led to the combined scheme of safeguards. And the salient features of the schemes are: first one, translation and publication of important rules, regulations, notices into all language which are spoken by at least 15% of the total population at district or sub-district level. Second, declaration of minority language as second official language in districts where persons speaking such language constitute at least 60% of the population. Third, receipt of and reply to representations in minority language, instructions through mother tongues, minority languages at the primary state of education instruction, through minority languages at the secondary stage of education. Fourth, advanced registration of linguistic preference of linguistic minority pupils and inter-school adjustments. Fifth, provision for textbooks and teachers in minority languages. Sixth, implementation of 3-language formula. And seventh, no insistence upon knowledge of state's official language at the time of recruitment. Eighth, test of proficiency in the state's official language to be held before completion of probation. Ninth, issue of pamphlets in minority languages detailing safeguards available to linguistic minorities. And 10th, setting up a proper machinery at the state and district levels. To summarize, we have studied in this lesson that the OBCs and the minorities have become assertive and politically dominant in India during the post-independence period. Although their assertion is more visible in the recent past, the process of their assertion had started much earlier. The policies of the state, emergence of conscious sections among them, and influence of various ideologies, an urge for political and social recognition can be accounted for their assertion. In India, welfare policies are an integral aspect of the development model, and this type of development model in India aims to improve people's lives by reducing social and economic disparities. From the time of independence, the state has played an prominent role in this. The state implemented policies that significantly reduced poverty, untouchability and gender inequity. Poverty, socioeconomic inequality and gender discrimination on the other hand continue to exist. This is due to issues like corruption and lack of transparency which impede the execution of a welfare based development plan. Since the 1990s, the market has shared the monopoly of the state introducing development policies. Keeping in view, the policies are framed to protect the rights of the backward classes and minorities. The Constitution empowers and directs the state for welfare of these backward classes also. A number of castes has been identified as backward and now they are known as other backward castes. For these castes, reservations have been made in jobs and educational institutions. Other measures have also been adopted for their upliftment and welfare. The Constitution of India as such makes adequate provisions for treatment of all equally, prohibits practice of discrimination and empowers and directs the states for protection and promotion of the rights of the vulnerable and marginalized groups in the true spirit of democratic, secular and welfare state. The developmental discourse in India has largely been growth centric. However, welfare oriented policies continue to be introduced by the central and state governments and are resulting in removal of deprivations of the weaker sections in a considerable way.